All right, once again, everybody, good morning. I call the February meeting of the Tennessee Real Estate Commission to order. And we will go ahead and begin with the public disclaimer. Ms. Baker.
Notice of the February meeting of the Tennessee Real Estate Commission, including date and time, has been noticed on the Tennessee Real Estate Commission website since August 7th, 2025. Additionally, this month's agenda has been posted on the website since Monday, February 9th, 2026. Individuals who wish to make a public comment on an item listed on the posted agenda during the scheduled public comment period will need to sign in on the approved sign-in sheet or by placing their name in the chat box online. It is requested that comments be limited to 3 minutes out of respect for other speakers. I will now call the roll. Chair Diaz.
Here.
Vice Chair Smith.
Here.
Commissioner Moffitt. Commissioner Begley. Here. Commissioner Torbett. Commissioner Gwynn.
Here.
Commissioner Rampy.
Here.
Commissioner Tucker. Commissioner Gahn. Chair Diaz, we have a quorum. For those here for the Fresh Start Act applications, you're not required to appear once we get to that section, but you're here. And so thank you for joining us today.
Thank you, Ms. Baker. For the prayer and pledge, I will turn to Commissioner Smith.
Commissioner Diaz, if we can have a moment, we have a technical issue. No one is able to hear us, so if you would entertain us by giving us a brief moment to fix that issue, please.
Okay, thank you. All right, thank you, Ms. Baker. All right, first item on the agenda is to adopt the agenda. So is there any amendments to the agenda? Hearing none, is there a motion? Got a motion to accept the agenda from Commissioner Smith. Is there a second? Seconded by Commissioner Tucker. All those in favor in adopting the agenda, please say aye. Any opposed? Hearing none, that motion carries unanimously. Next is the approval of the minutes. Commissioners, are there any changes to the minutes from the December meeting? Hearing none, is there a motion? Got a motion to approve by Commissioner Gahn. Is there a second? Seconded by Commissioner Smith. All those in favor of approving last meeting's minutes, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. We don't have any informal appearances this month, but before we turn to the Fresh Start applications, I want to turn the floor over to Commissioner Rampy. He's been appointed recently. We've been through a couple of meetings and he hasn't been able to say hi to everybody. So I wanted to give him a chance to do that. Commissioner Rampy.
Thank you. Well, I don't know where to start. I've been in the real estate business in some form for decades, and I love it. I love what we do. I love how we serve people. And so I've lived in Nashville for about 40 years. I came down from Northern Virginia. My wife and I have 4 children. Our youngest is a freshman in college, so we're not empty nesters because she shows up all the time. But anyway, we are proud to call Nashville home and have for a long time, and it is a privilege to serve on this commission. Thank you.
Thank you, Commissioner Rampy. Ms. Baker, this is the first time we've had Fresh Start applications as a separate category. Usually it's just informal appearances. Are they going to run the same where you give us a brief about the applicant and?
What we're going to do this morning is allow Anna, our program counsel, to go give everyone a refresher on the Fresh Start Act, and then I'll introduce those who are participating today. They're not required to be here, but thank you all for being here today. And we'll go over each applicant case by case and take it from there.
Ms. Matlock.
Hello, good morning. As we've done for the past several years, I believe this passed in 2018, the Fresh Start Act was passed by the General Assembly related to criminal convictions. So we have individuals that appear before the commission based upon statutory requirements that have been convicted of any felony or a misdemeanor related to theft of money, services, or property in the past 10 years based upon their application. And so just like this is a little different from that in that those individuals that are applying for licensure are required to appear before their principal broker. However, there is a provision in the Fresh Start Act in 6276 104B3 that states prior to submitting the application necessary to obtain a license, an individual may request written notice from the licensing authority which they seek to obtain a license concerning their qualification to obtain the license based upon their criminal conviction or their criminal history. So essentially the person is allowed to get a predetermination by the commission based upon their criminal conviction, whether the commission would grant the license based upon that or deny the license. So if we deny the license, just similar to those individuals that appear before us in the informal appearance capacity, we would be required to provide them written notice denying that application. However, this determination shall only apply exclusively to that individual and shall not be construed as like an advisory opinion on the licensing authority. And so it applies to the person based upon the information that they provide us. So these individuals that are appearing before you today have not applied for licensure, which is why they're not required to be here with their principal broker. They're also not required they're required to tell us what the information is for their criminal history, but we can't ask them for any additional information or documents because they just want it based upon the criminal conviction as it's been provided. So it's basically just like essentially a predetermination. So I don't believe we may have court documents, we may not, but we're just required to know what we do have court documents today. But if someone were to just disclose what the information was to us with the criminal conviction, we can't really like ask them for additional information. As Director Baker said this morning, the individuals are not required to be here, but however, as they are here, they can either stay or if you would like, to ask them questions, but it's basically just based upon the criminal conviction and what the licensing authority says. However, that person's license is not essentially automatically granted. So that person is still required to pass the test, provide all of the other information. And for any reason, like if we were to find out the person has occupational licensing discipline, then they would still be required to appear before their principal broker. But in this capacity, if you were to say, hey, based upon what we have, we would grant you a license, you would not see them in informal appearance capacity.
Okay. So basically, if we approve them today for their application, they can go ahead and get their license.
They can apply,
apply.
to get their license,
Okay.
and they would have to submit everything as required by our licensing.
And then staff would decide based on that submission if they have to appear again.
They would not unless for some reason, for example, we have not run TBI report. So if, for example, if we were to get their criminal history back and it were to be contrary or different from what we have today, then they would have to appear. But if it were to match, then they would not need to appear before you again.
Okay, and in circumstances when we deny the application, there's a battery of questions we have to answer in order to go on the record?
I believe there would be some additional questions, but just stating, I just want to clarify because I think I stated this before, the written notice to obtain their notice just must be limited to their criminal history. So we can't deny, we can deny a license based on another circumstance, but since we haven't done this before, I would probably go through those questions just to be sure, so we can give that information, make sure it's correct.
Okay, and in the event of a denial, it's a 6-month clock before they can reapply?
Yes.
Okay. Okay. Commissioners, are there any other questions for Anna?
So Anna, what is the reason for changing this methodology?
There isn't a reason for changing. This has always been in the statute, the predetermination, but usually what you have before you are individuals that have already applied for licensure, and therefore they come before you in the informal appearance capacity. So it actually provides persons, so if you were to say no, they don't have to go through, taking the test, paying the fees, those things, because they know that the likelihood of them attaining their license based on their criminal history is low.
So you said they don't have to appear here, correct?
Right.
So if you apply without appearing, you just do it on paper, or how do you do it?
So there is a specific form that's created by the department that individuals complete for this particular provision. They're required to let us know what their criminal convictions that they have and any additional information that they'd like to let us know about it.
So it's similar to the other form, but not the exact same form.
You'll find on your
Yeah,
iPad,
the form stack form is right there. So you'll see all of the information. It should be the first one that you see. It'll give you the questions that are asked in that circumstance, but the questions are a bit different from the form that you see in the application for a decision, just because this is a department-wide form and your form required is just Trec specific.
So Ms. Baker, are we handling you said you're going to introduce the applicants, and is it just they're going to give us the narrative as to the circumstances of their crime, and then
I have a summary, and if then you want to open up to discussion for the commissioners,
Okay.
I think that would be appropriate.
Okay, so we're probably not going to hear from the applicants today. They're just here to watch the proceedings,
They're here, so if you would like to ask them questions, you can.
but our scope is very narrow.
Right. You can ask them to the questions, but they're not required to do like the narrative beforehand.
I see. Okay. Any other questions for staff, commissioners? All right, hearing none. Ms. Baker, let's get started.
First, we have Michael Moreno. Mr. Moreno is seeking Fresh Start Act approval for his affiliate broker's license. He has a attempted first-degree murder conviction, attempted voluntary manslaughter conviction, and employment of a firearm during a felony conviction. And his application, and I believe a letter of recommendation can be found on your iPads, as well as his Davidson County court documents for these convictions. It's listed as 03A.
I didn't expect not to be able to ask questions, so my notes are a lot of interrogatories, but okay.
They're here, so if you want to ask questions, you can.
Mr. Moreno, are you prepared to answer questions today?
Yes, ma'am. Yes.
So just one observation I had, it seems about 15 months since he finished his service, his incarceration. Does that sound right to everybody?
Mr. Moreno, is that correct?
Yes. Yes.
Yes.
Ms. Moreno, do you intend to practice in Davidson County? Or anywhere?
Davidson County and surrounding areas.
Okay.
Did I see somewhere it had to be 2 years from the end of your probation or jail sentence before you could apply for a license?
That was the previous rule, but that no longer applies.
Thank you.
As of September 2025, however, we have not been implementing that rule since I've started here because it is in direct contradiction to the Fresh Start Act. Yes.
Commissioners, so we've had a chance to look over the information that he provided in his application. What do you guys think? Do you have any thoughts? I mean, the circumstances seem pretty straightforward. I guess the question we got to ask ourselves is, would we feel comfortable with this applicant working with consumers and clients in the state of Tennessee?
I'm a little apprehensive to ask questions or discuss because we're not supposed to ask questions, or I don't understand.
Not necessarily you're not supposed to ask questions. It's just that the persons are not required to appear before the commission. So if they are here, I would use that to your advantage because they are here. But they're just not required to be here, if that makes sense. So I'm not saying that if you want to ask questions, ask questions. I don't foresee any additional issues with asking that person questions. I think it might be actually helpful if you can hear it directly from the person instead of making any kinds of speculation since they are present.
Okay. So could we have them tell us the circumstances?
Sure, you can ask him.
Okay. Mr. Moreno, I think it would be illuminating for us to hear kind of the circumstances that caused you to appear before us today. So take as much time as you need and tell us everything you think we ought to know.
So you'd like to hear kind of what kind of happened?
Yes, just for this specific incident, yes.
Okay. I was kind of highlight. I was with I was dating somebody, and it just wound up being. I was dating somebody, and we were at a restaurant, and she texted somebody to come pick her up, and they staged the kidnapping, or it's in court documents. So they staged kidnapping to make it look like kidnapping, and then we went outside the restaurant. Some guy took her, and they left, and he communicated with me and stuff. And by the time we met to give ransom money, what was supposedly kidnapping, by that time, probably about 4 hours transpired. I met up with him. This time they had brought somebody else to tag along. So by that time that they showed up to the actual place, they caught me off guard because I was not waiting on them at that location. I told them to meet me at a McDonald's, and by the time that happened, I was actually away from the McDonald's in a separate parking lot. And before we actually met up, there was text messages saying that she was going to keep being raped. She had a broken nose, busted lip, black eye. They were going to keep doing it until I paid the money. So, and like I said, that had happened within 4 hours of the time that she was picked up, supposedly kidnapped. Um, then eventually, like I said, I agreed to meet him at a McDonald's, and I was in this separate parking lot away from the McDonald's. And by the time they showed up, they had missed the entrance to the McDonald's and all that stuff. They showed up, and they showed up to the side where I was at. I was outside the vehicle. And when they showed up, I had a gun, and they had threatened me with if I was going to do anything, they were to shoot me, they would kill her. So obviously, they told me not to call the cops, so I didn't. And when they showed up, when I showed up, I'm sorry. When they showed up, I was outside the vehicle. The gun was down by the seat, and I shot at the car. So that's what got me there. So,
And that's when a cop showed up.
no, well, what ended up happening is there was two guys in the front. They got hit. She accidentally got hit. The window tint of the vehicle. The window did not break, and the window tint diverted some of the slugs towards the back where she was at. She got hit. The two gentlemen ran to a Taco Bell. That was the closest thing there. And then she was hit. I took her to the hospital. I dropped her off. And then eventually I got stopped by the police.
So was all that staged? You're saying, was she in on
Yeah.
the staging?
Yes, the detective interviewed all three of the victims, and she confessed that none of that was supposed to happen. They were just supposed to get money from me. So they staged all of that so I can wind up paying money, and then I guess letting her go to make it look like, hey, you paid, she's free. So, but there's court documents and all the discovery where they found all those messages that she was being beat up and raped, and so it's not like what they made it out to be. So, but at the end of the day, I still shot some people, and I had to pay for that. So, but all the court documents and stuff, I can get that and provide that.
How old were you at the time?
29.
Were you running with a different crowd than now kind of deal or just?
I was just, I wasn't really, I wasn't really hanging out or running with a different crowd. I just wasn't hanging out with nobody. So,
Mr. Morano, tell me where you are now in your life.
I currently work for my family business. They do bookkeeping for small businesses and stuff. So that's where I'm at right now. I used to work for them before this incident happened. I've mainly been close to my family and everything. And around that time, that's when, life happens. So we kind of don't realize where we're at until it's kind of too late, or until we hit rock bottom. So, but now I'm back with them. I work for them. As of right now, my mom plans to retire sometime this year. So between my sister and I, we are going to take over the family business. And actually, my sister is a real estate agent. So I have strong ties to my family. I'm doing good. I go to church, and I'm trying to stay within between positive people and mentors. So
Commissioners, if you have more questions, if not, the floor is open for a motion.
I have one more question. Are you prepared now to go to work at a particular real estate company, and would that be where your sister is?
I'm. That is the plan.
Okay. I guess my thinking is, the company that you're going with, well, you'll have good mentors there and good instructions and, some people that can help you face some of the issues that you'll have as an agent.
Is that a statement or a question?
That was a question.
Oh, I'm sorry. Yes, there's plenty of people that's there to help me out, including my sister. So she's laid it out for me that real estate is not easy. So it's not a get rich type thing. So it takes time and work, put in effort to make things possible. So
I have a question. The person that gave the letter of recommendation, Mrs. Fernandez, who is that?
that is my coworker.
Your coworker? Okay.
Yes.
Commissioners, what do you think?
I have another question.
Go ahead.
Is your sister is an affiliate broker
Yes.
and the managing broker at that firm is willing to take you on?
I haven't completely, we haven't completely asked that question yet. But the honestly, the thing is, I just want to see before I go forward if there was any way to get pre-approved, obviously. So, but there is a good chance that would happen.
Commissioners?
I guess I'm just thinking out loud, is, a little bit what it seems like a reaction to use a gun versus calling authorities. So, and that happened how many years ago? You were how old at that time? It was about
21.
8 years ago. So you responded with a gun versus doing some other things. That's a little concerning to me. So I guess that's just a statement.
Did you, while you're in prison, have any training or classes or education stuff that you took? Or just tell me what your time in prison was like?
I did a couple classes, group therapy. I took a paralegal course in prison. Got a certificate in legal assistant, paralegal, and then I did an advanced course in business and corporate law. And then towards the end of my sentence, I was part of a program called Transition, where you take classes for 3 months. They teach you about finance and economics and how to save your money and to use your money properly. And then they find you a job on outside of prison, and you go out into the society. You wear an ankle monitor, and you work. You make minimum wage. So I did that for about 2 years. Worked for 3 different companies. I can get you names, numbers, and get you recommendations if you want. I did that until I was released.
Thank you.
Commissioners, is there a motion or further questions?
I'll make a motion that we approve.
Commissioner Gahn makes a motion that we approve this applicant. Is there a second? Last chance.
Second.
Commissioner Bagley seconds that motion. Is there any further discussion on the application? Commissioner Gwynn.
I've got a question. I guess we're approving, subject to, what are we approving? I mean, he doesn't have a principal broker yet. In the event,
Taking the test or anything. We're just, this is.
I think we're deciding if he will apply.
give him a shot at getting a principal broker, passing an exam, et cetera.
He didn't want to go in front of anybody.
Yes, I think we're deciding if it, based on his application, if he were likely to be approved for a license. And unless there's something new discovered with the application for his license, he won't appear before us again.
That is correct, unless the TBI report says something different.
We're
So-
opening up the door
We're opening up the door
for him to
Eventually
like
apply.
anybody else.
to eventually apply.
Yeah, he'll have to take the required 90 hours of pre-licensing education. He'll have to submit fingerprints for a TBI report, as well as pay the necessary fees and pass the state and national exam to be licensed in this state.
So we're saying right now, with what we know about this application right now, it's likely we would issue a license unless we discover something new that requires him to appear before us again.
But he doesn't have to come back again.
Will you turn on your mic, please?
He doesn't have to come back again with his principal broker.
Unless there's something that's different on the TBI report, or unless he has another professional license where there was discipline, then no, he would not have to reappear.
I hope I can get away with this question. Is there any criminal history before this?
I don't have his
No.
TBI report.
This is your only interaction with the law? Okay.
Yes. Yes.
All right, so we've had a motion to approve properly made and seconded. If there are no more questions, let's go ahead and vote. All commissioners in favor of the motion, please say aye. Any opposed?
No.
Ms.
Ma-
Baker, will you call the roll?
Thank you so much. That's what I was going to recommend. One moment, please.
We have 7 commissioners present today, so a vote on a motion requires 4 votes
All right, Chair
to
Diaz,
pass. A vote aye.
Vice Chair Smith,
No,
Commissioner Begley, Commissioner Gwynn, Commissioner Tucker, Commissioner Rampy,
Aye.
Commissioner Gahn.
Aye.
I believe the ayes have it.
By my count, the ayes have it on a vote of 4-3. Mr. Brainer, congratulations, good luck. And you can stay and listen to the rest of the proceedings, or you may go on with your day. Thank you,
Okay.
sir.
Okay. Thank you all. Thank you.
Next, we have Ms. Brittany Garrett. Ms. Garrett is seeking Fresh Start Act approval for her affiliate broker's license. She has a felony conviction on possession of a Schedule II drug. Ms. Garrett, are you prepared to answer questions today? Can you turn on your mic, please? Are you prepared to answer questions today?
Yes, ma'am.
All right, commissioners, you will find Ms. Garrett's application, her Fresh Start application, on your iPads. It is listed as 03B.
All right, Ms. Garrett, the commissioners have been provided with your application. We've had a chance to read them, read your submissions. But we are, as you can see, we're interested in hearing the narrative and your point of view on this story. So if you wouldn't mind taking a few moments just to describe the circumstances that have caused you to appear before us today.
Like I said, I'm a convicted felon, and I had to just find out what I needed to do to appear from y'all to just to see if I would be eligible to get it. And my convicted felons, it just leads to me being well, it came from me just being young, growing up with nothing, and saw how to get fast money. And then one day I just wanted to change my life. So I just got my life together, and now I'm a restaurant owner, and I just want to be a part of doing other stuff, like whenever the restaurant business is slow. And I have friends that's into selling homes, and I want to be a part of being able to provide people their forever home.
If you wouldn't mind, tell us about the restaurant and the catering business.
Well, I started my restaurant back in 2020. It was it was hard because it was during COVID. But so let me just start from the beginning. So I got in trouble in 2028. I needed to change my life and get rid of everything that was bad just around me. So I lost my sister in 2020 of January, and the last thing she wanted me to do was to open up a restaurant. Being that I don't come from money and I had quit, selling drugs, it was just really hard for me to do that. So I had started working at Logan's, and then we were off, and they paid us for COVID for being off. So I saved all my money. And I started my restaurant 9/11/2020. I was able to honor her wish. And my love come from cooking is from growing up. It's from growing up with less and not having food and stuff. So it gave me a love to cook and to feed people. So to honor my sister's last wish she wanted me to stop working for people and start my own restaurant. So with all that money that I had got from COVID, I just saved it up. I saved it up, and I was like, do I need to start a business during COVID? Because people were losing their business during COVID. So I just did it, chances make champs. I woke up. I wanted to be better one day. I was just so tired of that old life, the abusive relationship I had been in for 10 years. I just didn't need none of that no more. The fighting, just being a bad person. I didn't want to be that person no more. So I got my restaurant. I opened up my restaurant. Um, we're we're still open. We opened 9/11/2020, and here I am today. I mentor little girls. I go to the high school and I go talk to little girls. They have this women's series they do every month, and they pick me. And the first time I ever went to go do it, I told them everything, the good, the bad, me going to jail, selling drugs. I told them everything, but at the end of it, I couldn't tell them how I had dropped out. I told them I dropped out of school, but I couldn't tell them how I had went back to school, and that really bothered me and it inspired me. So that day I left, I went and found this adult high school, and I enrolled in it, and I got my high school diploma within a month. And then I got accepted into UTK in Knoxville for this culinary school. They picked 12 people, and I was the 12th person they picked. And I got a lot of support in my hometown. I'm pretty sure all you guys are familiar with Lodge Cast Iron Skillet. Um, Me and the CEO were really, really good friends. They do a lot of business with me. He gave me $4,000 to pay for my apartment up in Knoxville while I went to school. They supported me the whole way. I graduated at UTK Culinary Program March 2024. And I was able to relocate my business, get a bigger business. And now I just want to help people. Um, we do so much at my store. Like when they cut off the SNAP balance for people back in November, we fed people the whole time. I get a lot of support from my people, and I just want to be able to have some cushions to fall back on when times it is slow. So Yum Yums is called my restaurant, and that's my catering, and I'm gonna always have a love for it. But I have to be realistic because sometimes it's slow. So I want to be able to fall on cushion when those times are slow. And I have some great friends that's in real estate. One of them, she has her own real estate company. She's my landlord at my restaurant, and we're right next door to each other. And then I have a best friend who is a real estate agent as well. So I just want to I like helping people, and I feel like me helping somebody find a forever home is still like me helping, with my nonprofit organization. It's called Quiet Closet. We provide young girls with clothes, and we call it Quiet Closet to keep it discreet. We don't take no pictures of nobody getting clothes. Sometimes kids are mean to each other, so we keep that real discreet, and we try to provide a safe place. Sometimes you can tell a complete stranger some bad things that's going at home versus that you can tell somebody else. So I don't have any kids. So a lot of the girls I do mentor, they call me auntie. So I like to provide a good space for that. And that's just what led me to here today. I'm like, I try to help so many people do so much, and I want to become a homeowner. That's one of my goals. So I just feel like that'd be helping people too if I can help them find a forever home.
Thank you so much, Ms. Garrett. Commissioners, any
welcome.
questions for Ms. Garrett? Otherwise, the floor is open for a motion.
I make a motion to approve.
I have a motion by
Yes,
Commissioner. I have a motion to approve by Commissioner Tucker, seconded by Commissioner Smith. Any further discussion on the application? Hearing none, let's go ahead and vote. All those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion passes unanimously. Congratulations, Ms. Garrett, and good luck to you.
Thank y'all so much.
You have a good day. You can stay and listen to us, or you can go on about your business.
Thank you. Have a great day.
Yes, ma'am. Next item on the agenda is, go ahead, Commissioner Gwynn.
Could I ask Anna a question before we move on to the next?
Sure.
Regarding the form, the Fresh Start form, does it need to accompany, or does the Trec form need to accompany it, or could someone come here just with that Fresh Start form?
That's correct. It should be just the Fresh Start Act form. I see that we've given you too many documents today, and in the future, you won't see those.
Well, I was a little confused on hers because there's a question. If you look at her form, it says name of conviction, and she put the number 3 there, whereas Mr. Marino, when he filled his out, he put what it actually happened. So
Right,
if
I
she
think
had
that
just
was
submitted
his
that,
user error.
that's a mistake, right?
Right,
Okay.
but
Would we have,
she did submit copies of her court documents that have the information provided, so that would be, if we will present to you the information that they provide us with.
but if they
And-
fill the form out wrong, you would tell them to.
Right, then we would ask
Okay.
for additional information. If they didn't, then it would come before you and you can deny it for not knowing what the convictions were.
Okay, got it.
Yes.
All right, thank you.
All right, Ms. Baker, are we ready to go with the medical waivers?
Yes, we have 2 medical waivers today. The first one is Jay Lamar. Mr. Lamar's retired real estate license expired April 20th, 2018. He is requesting a waiver of $1,400 in fees. His letter his statement and letter from physician can be found on the iPads. He has taken the trace course. As you all know, if a retired license expires, they have to pay a civil penalty and then to get their license current, what they would have paid if they would have kept their license current. And so that's why the fee is $1,400.
So I see in here the note from the commissioners. I see in here from the note from his doctor that, it seems his health issues seem to be cardiac issues since it comes from the Methodist Cardiology Group.
It comes from I believe a nurse practitioner.
So I guess we're to speculate that in retiring his license, he thought he didn't have any maintenance responsibility after that.
It's widely known that if a retired license, and we send documentation every
Okay.
2 years that you owe a fee to keep that license in retirement.
So those notices again go to
It goes to your
the
home
broker
address.
and home address as they've
Well,
given it to you.
his license is retired. He doesn't
Okay.
have a broker, so it goes to the person's home address.
The last address they gave you.
Correct.
Okay.
And that was not returned, correct?
I don't have receipt of it being returned, and we track every piece of return
Right.
mail.
Okay, thank you.
Will you please use your mic?
On the waiver request, it says firm license retired. So is he an individual, just a sole proprietary?
It's my understanding the license he was once affiliated with is now retired. That firm license is now retired, so he'll have to affiliate with a different firm.
So he retired his license and the firm retired their license?
I am not sure if this is the firm that he retired, but the firm license that he was once associated with is retired.
So I've got that his license expired, or did he retire his license?
His license expired in retirement. So a retired license still renews every 2 years. It keeps the same cycle as if you are an active agent. And to get your license out of retirement, you take 16 hours of continuing education, including the Trec course, and then pay the $75 fee, or excuse me, pay the $25 fee within that 2-year period, and then you have your license back.
So I'm sorry so is his license?
His license was retired.
It was retired.
It was retired, and in retirement, he allowed it to expire.
So with that,
Mm-hmm.
and it's been a long time.
It has.
So typically, would we not make them retest and redo everything, or?
Well, the law recently changed, or the rule recently changed, in that if a license expires while in retirement, there's a path where you don't have to retake the exam. And the path would include the $1,400 in fees. However,
And
if
the
he were
16
to just retake the exam, it would start his license cycle over, and he would not have to pay the fee.
So he can either pay the fee, do 16 hours, or start from scratch kind of deal. It's two options.
Pay the fee, do the required continuing education, because I believe it's, Anna, correct me if I'm wrong, for every cycle period, you have to make up that continuing education.
So. He would basically.
And it's or the trace course. Or the trace course. Or you can retake the exam and pay no fee. So he still has two options, and he's requesting relief from the fee.
So
That-
would he come back as a broker though? Or as an affiliate?
A broker.
He'd come back as a broker.
Mhm. As long as he completed his 120, and we would verify that information.
And he's really asking for half, right?
He's-
In his letter.
We won't give the whole, we won't have.
He's asking, Mr. Lamar's asking for the full 1,400.
Well, in his letter, he says if full removal cannot be granted, I kindly ask that the funds be reduced by half.
It does say that, yes.
Yeah, in his letter.
Yeah, and his second sentence in the third stanza, yes.
Needs license.
How long has he been expired out of the business?
Since 2018.
Oh, my.
Licensed. 95. So he was 95 till. Last question.
Yes,
I
sir.
promise. So I've got that his license, he retired it, then it expired in 18. When did he retire it?
He retired his license. Let's see here. Let me go and check when he retired his license.
That's
I did not write that down.
The note the doctor sent said back in 2019, Mr. Lamar had his real estate license retired,
which doesn't make sense. for
which,
the
yeah,
expiration.
the dates don't date.
Just a moment, please, as I bring up our system.
What's the trace class? I had to be done.
It's
Anna, while she's looking at that, to be clear, so my license expires on 2018. We're confused about the cumulative part or just the net part of 16 hours. So
So-
every cycle, they were supposed to take 16 hours?
There are two options for individuals whose license lapses while in retirement. The first is they can take the outstanding continuing education for the amount of time that has been lapsed. So 2018, since 2018 and now, it's 8 years. So that would be,
14, 16?
yeah, which is, I think, 64. Don't quote me, I don't math. 64 hours. Or the other option would be to take the 30-hour trace course.
Okay.
Yes.
And he put his license in retirement January 18th, 2018. So where it says firm license retired, that's actually his broker's license and when it retired.
Okay.
okay.
So he was licensed for, how long is that, 22 years before?
So if we accept his deal, which is half off, how many hours of education will he have taken since? Or continue, how many hours will he have taken since, let's call it 2018? Just that trace course, is that it?
That's all he has taken since 2018.
But he's not asking about education. He's asking about late fees being reduced
Correct.
and whether or not he has to retest.
But I'm just trying to say, if we said no, I mean, he wants us to waive the fee for the
Right.
most part,
Right.
so he doesn't have to take a bunch of education, essentially. But
He's just asking you to waive the fee to waive the fee.
Education?
It has nothing to do with the education. The fee doesn't.
But if we said no,
If you
his
say
only
no,
option, as Denise was saying, is he could go through, take the test again and
he
do,
could.
Start over.
and basically start over again, pay a smaller fee and
But also have to do the pre-license.
Well, he's already done.
80
Never
hours.
mind. Yeah, so no, he would just have to, yeah, not, excuse me, don't listen to me about well, listen to me, but not about that.
Yeah.
About the pre-licensing education. He would not have to do that. He would just have to pay, what is required to retest and reapply.
But then he would get an affiliate license.
He could keep his broker license. He has the experience to upgrade to that.
Okay.
I make a motion that we deny this request.
Second.
Commissioner Smith makes a motion to deny the request, seconded by Commissioner Gwynn. Any further discussion? Hearing none, let's vote. All those in favor of the motion, please say aye.
Aye.
Any opposed?
Yes, me.
By my count, that is a 6-1, 6 in the affirmative.
Yes, that's what I have. Yes,
All right,
the motion passes.
motion passes. Thank you, commissioners.
Our next
Ms.
waiver.
Baker.
Our next waiver request is Crystal Harris. Ms. Harris is requesting a medical waiver in the amount of $600 and the approval to apply 3 hours of continuing education completed after her 4th year towards her 3-year requirement. Her statement and letter from physician can be found on the iPads.
So the late fee is
The-
because she did complete her 120 or?
The late fee is there because she did not complete her 120 within the first 3-year period.
Okay.
And she thought she completed it. She was at 117 hours, but it's my understanding that she duplicated a course and you're not allowed to duplicate a course. So she took 3 hours after her license expired. She took 3 hours January 27th, 2026, and her license expired January 5th, 2026.
And when you say her license, that's the upgraded broker license?
Correct. And we couldn't renew her license because she didn't have the required CE. She only had 117 hours.
So she's at some kind of expired grace right now?
Yes.
Are we allowed to?
Please turn on your mic, sir.
Oh, I'm sorry.
And Commissioner Gwynn, if you could
Yep.
turn yours off. Thank you, sir.
Are we allowed to consider things outside the actual request?
Yes, that's in the purview of the commission. Yes, sir.
Specifically, my concern isn't the waiver of the fee, it's her ability. This letter that she included describes significant fatigue, cognitive difficulties, often referred to as chemo brain. Is she capable of being a principal broker and running a firm?
I can't speak to that, sir.
Okay, I understand.
I'm going to make a motion that we accept this waiver request.
The waiver of the $600 or allowing 3 hours to be included in the 4-year.
Both.
Okay.
So Commissioner Bagley makes a motion to accept the 3 hours of late and to waive the fee, seconded by Commissioner Tucker. Any further discussion on the motion? Hearing none, commissioners, let's vote. All those in favor of the motion, please say aye. Any opposed? Hearing none, that motion carries unanimously. Thank you very much, commissioners.
All right, next we have our education report.
Ms. Brittany, what do you got for us today?
Yay, it's my time. Okay. Commissioners, I'm excited to be presenting the education report for you today. On pages 1 through 6, you'll find only the 18 candidates labeled FI, excuse me, FI1 through FI18 who have applied to be certified Trec instructors. The individuals presented today have met the qualification for instructors as listed in Trec Rule 1260-05-.04.
So it is a large number of new instructors. Is it just renewals of instructor licenses, or is these all brand new instructors?
These are all brand new.
Commissioners, are there any instructors you'd like to pull for further discussion? Hearing none, is there a motion to approve candidates FI1 through FI18?
Motion to approve.
Have a motion to approve by Commissioner Gwynn. Is there a second?
Second.
Seconded by Commissioner Smith. Any further discussion? Hearing none, let's vote. All those in favor of the motion, please say aye. Any opposed? Hearing none, that motion carries unanimously. On to the courses, Ms. Britton.
Next, on pages 7 through 18, you'll find the total of 61 courses labeled F1 through F61 that providers have applied for your approval to offer continuing education credit hours to licensees. All courses presented today have met the requirements set forth by Trec Rule 1260-05-.03, and each course has been assigned to one of the 17 subject categories as mentioned in Trec Rule 1260-05-.035A.
Commissioners, are there any courses that you'd like to pull for further discussion? Hearing none, is there a motion to approve courses F1 through F61?
Motion to approve.
I have a motion to approve by Commissioner Gwynn. Is there a second?
Second.
Seconded by Commissioner Tucker. Any further discussion? Hearing none, all those favoring the motion, please say aye. Any opposed? Hearing none, that motion carries unanimously. Ms. Brittany, do you have anything else for us today?
Yes, I just wanted to mention, lastly, on page 19, you'll find the exam snapshot for all exam types of pass-fail rates for the months of December and January, as well as a cumulative exam snapshot for all of 2025. On pages 20 through 34, you'll find the more detailed monthly reports for each exam with the breakdown of pass-fail rates by the pre-licensing provider. And if there is no other questions, that concludes my report.
Thank you very much. Commissioners, any questions for Ms. Brittany? Hearing none, on to the Executive Director report. Ms. Baker.
Thank you. I have, my report is before you on your iPad today. There is a typo that you will see on the open and closed complaint report. The last line on there should read January 1st, 2026 through January 31st, 2026. And so we'll get that updated for the record. Many of you are coming with us today to the Hilton Nashville, where Tennessee Realtors is having the Tennessee Excel Summit. I just want to make sure that all of you, except for I believe Commissioner Begley and Commissioner Gwynn, will be in attendance. Is that correct? Yeah. Okay, very good. I know they are looking forward to us being there today. I do have a program update for the high school program. If you would share your screen. We have a small presentation for this program, a few visuals. We are running the computer, or excuse me, the conference from his computer, so bear with us for a moment. All right, let me see if I can share my screen. One moment. All right, if we can put that in presentation mode, please. Thank you kindly. This is an update on the high school program. In 2025, Trek enrolled 158 participants in the program. 42 of those participants completed the 90-hour coursework. Of those 42 students, 8 are not now licensed. Hold on just a second. There we go. Oh, goodness. Hold on. So, yes. So, in 2025, Trek enrolled 158. 42 are now 42 completed the coursework. 8 are now licensed. We've made improvements to the program in 2025. We added 3 milestones to help participants through the material. The first milestone was to watch the Kaplan commitment video within 14 days of enrollment. The second milestone was to complete at least 13 units or 30 hours of seat time. The last milestone was participate in the course for new affiliates and the time listed above. So it's either sections 1 through 5 or at least 15 hours of seat time within 90 days. We did grant extensions to participants in the program if they did request them. And if they did not request an extension, then we removed them for the program after we gave them notice several times. Kaplan also offered a monthly webinar for participants of this program, just particular to the Tennessee cohort. Here you see the year-over-year comparison. In 2025, we did enroll less students. However, participation was greater because we removed the students that were not hitting their milestones. Some good news to report is that an additional 9 students from the 2024 cohort are now licensed affiliate brokers, and I anticipate the 2025 number going up in the months to come. As many of you all know, you take the pre-licensing education and then kind of sit on it until you're ready to proceed with your career in real estate. And so that's why we saw the uptick in numbers from 2024 to 2025. You can stop sharing your screen, Denny. Thank you. The spring newsletter is scheduled for release the week of March 23rd, 2026, and the 2026 cohort will be formally announced in that publication. Following the newsletter release, we will begin accepting program applications on April 1st. Trec has allotted funding to support 109 students in completing the program. As in previous cycles, participants will be required to meet specific performance milestones throughout the program. These benchmarks are designed to ensure steady progress and responsible use of program resources. Participants who fail to meet the required milestones will be removed from the program and replaced with individuals on an established waiting list until all funded positions are fully utilized. Additionally, Kaplan's contract expires next summer. I believe the date is June 1st. So this will be the final year that this program will be offered under the existing contract. And that concludes my prepared remarks, and I'm open to commission member questions.
So you said that the applicants or the students, they sit on their taking the exam until later. Is that typically at the end of the school year?
It just depends. We looked at our 2024 list, and Denny helped me, and we scrubbed that list of everyone who completed their pre-licensing education to our current licensee database, and it skyrocketed 9. So we had 3 that were licensed last year around this time, and an additional 9 students or participants in the program from 2024 became licensed sometime last year.
Okay. So it's just whenever the timing's right for them.
Mm-hmm.
Are the participants pretty much spread out throughout the state?
They are.
Pretty much
Mm-hmm.
as you would expect?
It's concentrated in population centers,
Right,
but it's
but-
spread off across the state.
Any other questions for Ms. Baker? Ms.
You
Baker, you
said
have any?
the
Go ahead.
contract expires in June of next year, I believe.
Yes.
Is there any intention to renew it? It seems like a pretty
I
good
believe
program.
that is up to the purview of the commission if you guys would want to consider extending the program further.
Okay.
We would have to issue an RFP in order to do that, but it is definitely plausible.
Is that something you'll ask us when the time comes, or do you want us to
Yes,
consider that
today
now?
is not the day to
Today's
have
not
that
the day.
conversation.
Okay. Anything else from Ms. Baker? Ms. Baker, is there anything else to report?
No, that concludes my report.
All right, moving on. We got the public comment is next.
Is that-
I know there's a 3-minute time limit for speakers. Who's going to be keeping time?
We will keep time, but I don't believe anyone signed up. Okay, we have no one signed up for public comment period.
All right, so hearing that there are no speakers either present or online, I will close the public comment period. Next item on the agenda is the legislative update. Who's going to give us that? Ms. Matlock? When you are ready, Ms. Matlock.
Okay, there are two matters that I'll be discussing today. Well, maybe three. Let's see. The first one is going to be SB 1786. This is a bill that will amend provisions related to our vacation lodging services. Essentially, it is adding new language that will exempt licensed affiliate brokers or brokers from also fulfilling requirements to be a designated agent for our vacation lodging services. However, the vacation lodging services will remain under the supervision of the individual's principal broker. So if you are a licensed affiliate or a broker, you are no longer required to also obtain a designated agent license, which at this time still has essentially, there's an 8-hour continuing education requirement for that. So you can still serve as a designated agent, but it is not required that you have to essentially hold both licenses. However, if you're an affiliate licensee or a broker under a principal broker, the principal broker for that person will remain responsible for the supervision of that individual. Any questions? Okay, seeing none, I will now move on to SB 2224. This bill is going to amend several provisions of our statutes, and I will give you that information currently right now. So the first one is going to be changes to 6213-104, as well as 6213-112, and 6213-313. So I'm and 6213-317. So I'm lumping all of those together because they're making several changes to, the changes are very similar. The first is going to be requiring, we're substituting generally in both of those the language where it states that a matter is if it's required to be exclusively mailed, electronic mail is provided. So this will remove the mailing requirement. Well, it's still there, but it provides that and those are going to be in the matters of related to E&O suspensions, and then complaints that are being sent out and those types of matters. So instead of where it just says certified mail, it will say by regular or electronic mail. Any questions? Okay. The next provision that is going to be amended is going to be a change to 6213-303H1, and that is going to be our provisions related to the 120 hours post-licensure continuing education. Right now, it has the language in there 3 years, and the 3 years is going to be amended to 4 years. It's going to be changed, go from 3 to 4. So after you obtain your broker's license, you have 4 years to complete 120 hours of continuing education. The next provisions that are going to be amended are going to be found in 6213-309. These are related to our business and business requirements for signage. The first is going to remove the requirement that individuals are required to submit to the commission a zoning letter. So we're no longer going to require that of individuals. You're required to conform with zoning, but it's not going to be required to submit that information to us as a zoning. So we are not going to ask for that on application. The next one is going to be, it's removing, this is going to be from 6213-309B1. It's deleting the language which shall clearly state that the broker is engaged in the real estate business as related to signs, because I don't know what that means. What you are required to put on your sign that makes us know you're automatically real estate business. Most signs don't have that. It just says, your firm or realty or whatever you may have you. And then the last one is going to be a deletion of 6213-309B2, and that is just like the zoning provision. So any questions related to that? No? Sorry, go ahead. In your microphone, you are still, the signing requirements are the same. However, the provision that says that you are required to make sure that your sign clearly states that you're engaged in the real estate business is being removed, because I don't know how you do that other than saying this is a real estate firm, which I've never seen on a firm sign anyway.
So, but that doesn't exempt the signs from the advertising rules. then?
Right, no, signs are still required. It's just that provision that I don't think we were looking at too closely.
Yep.
Yes.
Could you explain the zoning letter?
Interesting question. Yes,
As it
Commissioner
relates
Gwen.
to, you don't have to submit the letter from your local.
Ordinances to the commission before we were to grant a firm license. So if you tell us that you have zoning approval, we're not requiring zoning information for us anymore. But if you violate zoning ordinances on your own, that's on you.
Basically, we will not verify your zoning anymore. So once you submit a firm application, a requirement will no longer be to provide a zoning letter. Also want to make mention, this is just proposed legislation. Nothing
Right.
has been passed. Nothing has been signed by the governor. This is what is currently being proposed in different bills that Anna tracks during this session.
So I can't remove zoning requirements across the state. So if there are certain requirements that say you can't have your office in a certain area, then you'll need to speak with the Planning and Codes Commission of your own specific area. However, for the Real Estate Commission, we will not be interfering in it. So that is the zoning provision. Any other questions? Okay. The next one is going to be an amendment to 6213-312B12. And this is in our provisions where it relates to the enumerated offenses. So this one is a little bit different. Right now, post-licensure, if you are convicted of a crime related to theft, dishonesty, fraud, those matters, then the commission has the ability, unless you're required to notify us of that conviction within 60 days. However, if you don't, your license may be automatically revoked unless you ask for a hearing. However, in this provision, it's going to be expanded to include additional convictions in that area. So it would be, so it's going to say, if being convicted in a court or competent jurisdiction of this, of a felony or misdemeanor related to homicide, assault, battery, force, or any violence against persons or property, then it still has forgery, embezzlement, obtaining money under false pretenses, bribery, larceny, extortion, conspiracy to defraud, any crime requiring registration of the Tennessee Sexual Offender and Violent Sexual Offender Registration, Verification and Tracking Act of 2004, and any crime or similar offenses, pleading guilty or nole contendere in that. So we're expanding those convictions to include violent felonies or misdemeanors. Any questions? So this is post-licensure. Individuals that, so if you're licensed and you were convicted of first-degree murder, then you would be required to notify us of that information. And if you don't do that within 60 days, your license is automatically revoked. Okay.
Okay.
The next provision that we're going to be amending is going to, well, okay, I'll just tell you. Okay, it's going to be 62-13-319C. If you remember, this is the provision that is related to our current rules that are pending. It's related to individuals whose licenses have expired. Right now, the statute says more than 2 years, but this would be substituting more than 1 year, but less than 2 years. However, I believe that also will be amended in the future to more than 1 year. Period, not more than 1, but less than 2. So essentially what that would mean is if your license has been expired for more than 1 year, you would be required to pay back any required penalty fees and take the trace course, or you have the option to retest or reapply. Any questions related to this? Okay. The last statute I believe that I want to bring to your attention is going to be related to military families. So there is a bill that is currently pending before the legislature that would expand military licensing. So essentially right now, we have rules for military licensing that allow individuals that if you're on active duty, how you would obtain a license. So it's like essentially kind of reciprocal licensing. So in this particular bill, it states like if you are on active duty, I believe, or retired, and you have a license in real estate, or for your case in real estate, you would be the ability to obtain a real estate license here in Tennessee. And now, so right now it applies to military, members of the military and their spouses. However, this bill also includes dependents in that bill and as well. So this would allow licensing for spouses, active and retired military individual members, and dependents the ability to obtain licensure in this state. So licensure would still have to be the same, equal to, or greater than as it is now, but essentially it just expands it to military dependents. And then there is a timing requirement that would have to be we would have to issue those licenses in a certain amount of time to those persons. So right now it would, if this bill were to pass, conflicts with our current rules. So those rules would need to be amended.
How long is what's the definition of a dependent? I know the minor children are dependents.
That's a good question. That was it Dependent is not defined in the statute
Okay.
at this time. However, I believe it would be dependents as classified with the military, those individuals that are entitled to benefits as classified.
Oh, okay. So as the children of a military member, you're defined as a dependent by the military?
Right.
Oh.
So those are, I believe, the legislative updates that are most pertinent to this commission. As I've stated, and it was stated previously, these are proposed legislation. None of the legislation has passed or been enacted. We'll provide another update in April, so we may have additional information as to new language or whether a bill we know has either been passed, signed, or it will not pass during this legislative session. Okay, that's it for me if there are no questions.
Any questions from Ms. Matlock? Hearing none, I sense the commission's ready for a break. Let's go ahead and break for, let's go ahead and say 10 minutes and we'll come back at 5 after the hour, 10:05. Cases that commissioners have decided to pull are as follows. Case number 8, 9, 10, 11, 13, 20, 21, 22, 23, 24, 28, 45, 49, 53, 55, 56, 57, 59, 66, 71, 135, 136, 139, and 141. Are there any other cases commissioners wish to pull at this time? Hearing none.
Commissioner, I'm sorry to interrupt, but if I may,
Ms. Cooper?
the legal report, I would ask that number 16, which is complaint number 2025-052281, be deferred to the April meeting. The complainant submitted some additional information late last week that I haven't had a chance to review yet, and I don't know if it'll change my recommendation or not, but I need it to be moved.
What number was that?
Number 16.
No.
Yeah, we didn't pull 16. She's asking us to pull it.
No.
Pull it from consideration today.
Correct, and just move it to the
Defer.
April meeting. Yes, sir.
Okay. Okay, hearing no other cases to pull. Number 40. Okay. Any other cases? Hearing none, is there a motion to accept council's recommendations for the other cases being heard today?
Make that motion.
Motion made by Commissioner Smith. Is there a second? Any further discussion? Hearing none, let's vote. All those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. That also includes Ms. Cooper's request to defer case number 16 till the April meeting. All right. I guess I'll go first. Cases number 8 and 9, I'm going to consider those together. Hopefully that'll speed up things here. So my basic question is a lot of violation history with this respondent. What's the difference between the complaints in 8 and 9? Is there, I'm thinking I'm probably asking about the difference in the recommendation for a penalty.
The difference was the disciplinary history. I didn't think a $500 civil
Mhm.
penalty was appropriate for number 9.
Okay, and the information provided about the licensee in the heading, 9 is for the affiliate broker, and 8 is for the principal broker. I wonder if those two should be switched. Because case number 9 talks about supervision. Or did I read that wrong?
No, you didn't.
I must have, yeah, I don't think they're switched either. I must have transposed those while I was reading them. I apologize. Okay, I have no question. I have no quibble with the council's recommendation. Is there a motion to accept council's recommendation?
Make a motion, we accept council's recommendation.
Is there a second? I have a motion to accept council's recommendation for cases 8 and 9 made by Commissioner Smith, seconded by Commissioner Gahn. All those in favor of the motion, please say aye. Any opposed? Hearing none, that motion carries unanimously. Case number 10, that was me also. I just wanted to know if the respondent here still had an active license.
They do, sir. Or they have, I believe that they reinstated it once, they became concerned because of the complaint, and so they reinstated their license in 2025, but they are still not doing any brokerage activities.
Okay. All right, council's recommendation was to dismiss. Is there a motion to accept council's recommendation?
So moved. Second.
I have a motion by Commissioner Tucker to accept council's recommendation, seconded by Commissioner Smith. Any further discussion? Hearing none, all those in favor of the motion, please say aye. Any opposed? Hearing none, that motion carries unanimously. Case number 11. Go ahead, Commissioner Bagley.
Just. Can I just say something about number 9?
Yeah, go ahead.
Yeah, so at number 9, I mean, look at that history. So this is the John Grease of just cost of doing business. So I don't know what we can do, but, you know, they keep repeatedly getting those violations and they're just paying the fine. So
Yeah,
just wanted to note that, you know, I don't know what I'm wanting to know, but a lot of violations.
mhm. A lot of ad violations and,
Yeah.
you know,
I think that's why she said she increased the penalty from 1,000, from 500 to 1,000. 500 the first time, 1,000. You see on number 8, and then 1,000. Is that correct? Yes, Pam, Kim.
To 8s.
8's 500.
Yeah. Okay, I'm sorry.
okay.
That was something I wanted to mention and ready, sorry.
Okay. Case number 11. This was talking about business cards were not in compliance with the commission's ad rules.
Yes, sir.
Do we require the business cards to comply with the ad rules?
No.
Okay. Okay. I wanted to make sure about that. Very good. Council's recommendation was to dismiss. Is there a motion?
So moved.
Second.
I have a motion by Commissioner Smith to accept council's recommendation to dismiss, second by Commissioner Bagley. All those in favor of the motion, please say aye. Any opposed? Hearing none, that motion carries unanimously. Case number 20.
That would be, excuse me, that would be me. And I had a question. There was a penalty assessed, suggested.
Pardon, please. Are we going to discuss case 13?
We are 13.
I thought I heard you say 20.
Oh,
I did. I skipped it. My bad. Case
Oh.
number 13.
I'm sorry. I just knew it was time.
Go ahead. Case number 13.
Okay, on number 13, I see there's a penalty assessed for unlicensed activity, but there was not a penalty for not responding. Is that a penalty that we can add or should add?
Because it's unlicensed, we can't do the failure to respond.
Okay, very good, thank you.
Yes, ma'am.
Then I make a motion, we accept council's recommendation for 13.
I have a motion by Commissioner Smith to accept council recommendation with case number 13, seconded by Commissioner Rampy. All those in favor of the motion, please say aye. Any opposed? Hearing none, that motion carries unanimously. Now it's time for case number 20. I was on a roll there.
I liked it.
Mhm. So this is a general question I had just from my general knowledge, but this is the case where the firm didn't respond to the auditor in a timely manner. What's the clock for that when they receive notice? How long do they have to reply?
I'll let the executive director answer that.
I believe it's 10 days,
10.
and then we send a follow-up letter as well.
Okay.
And if they request an extension because they have to gather their records together, thank you, Kim, that they have to gather their records together, we will grant an extension. What we have found is that they continue to ask for extensions over and beyond 60 days. And at that point, you're just stringing the
Yeah.
auditor along. And so at
Okay.
some point, we have to close and open it up an administrative complaint because they could not find their records or just refuse to submit them, even though they keep stringing us along.
So, and that's what's happened with this respondent.
That is correct.
Council's recommendation was to assess a $1,000 civil penalty for failure to reply to the auditor. Is there a motion?
So moved.
I have a motion by Commissioner Smith to accept council's recommendation, seconded by Commissioner Bagley. All those in favor of the motion, please say aye. Any opposed? Hearing none, that motion carries unanimously. All right, so I'm going to consider 4 cases in block because they're all related, 21, 22, 23, and 24. So when I first read 21, I was thinking honesty and good faith came into play, which is 6213-4034. And if you read the allegations of the respondent, I felt like it met the threshold for honesty and good faith, but that's why I pulled it. And then this was the issue of the broker refusing to show properties of clients for another broker.
The complaint was against the broker for refusing to show homes that the broker was owned and developed and built with a spouse. They were refusing to show those homes to anybody that was affiliated with this other firm.
Okay. All right. And council's recommendation for all 4 of these cases was to dismiss. Ms. Cooper, you want to talk about why that was your recommendation?
This was done after discussion with my fellow counsel here with Trec. I felt like, yes, it's very messy. Yes, they are probably violating some of the multiple listing service requirements. They're probably violating some ethics requirements of whatever association they may be part of. But I didn't know that I could hold someone responsible for a civil penalty for refusing to allow people into a home or to show a home that they owned. I felt like that was, and so we did go back and forth quite a bit on that, but I obviously I'll do whatever the commission
Mhm.
feels like would be appropriate.
So do you know if the respondent was listing these homes as part of their firm?
My understanding, and I had to dig through a lot, was that they are listing them on their own.
So not in the MLS.
Correct.
Well, we have jurisdiction over licensees though. And here's my rationale, commissioners. You know, there are a lot of people in this world that I've met that I don't like and don't want to do business with. But in not showing the properties for this broker and people related with their firms, he's impacting the consumers. The consumers are the people that are there and that want to see the properties, not the agent. So, I mean, if you got a personal beef with another agent or another broker, and then you could say, well, I'm not going to show you any of my properties. I just think that is injurious to the consumers at large. Because now they can't see properties that they might legitimately want to purchase. I don't know, I just think it's exclusionary. I think it's far too much of, the whole, it's way too far when you're holding a grudge. I just think you need to get over it and go to business, do business. I mean, you don't have to go to and have dinner with him afterward, but
So are you recommending skill and care, or you think? a
I think it lands in the realm and it gets to the threshold of honesty and good faith. I don't think he's acting in good faith with his fellow agents, his fellow licensees, and
consumer?
and representing the consumers, which is this body's job. I think ultimately it lands on the consumer, even though
It harms the consumer.
it harms the consumer, even though his angst and his animosity is with the brokers and of this particular firm. That was my take. So I think it lands on that threshold, but council's recommendation for all four of these cases was to dismiss. Is there a motion for this case? Or these cases?
So what was the difference between the property?
Will you please use your mic, sir?
What was the difference between the properties? He's saying he allowed them to look at their firm's other properties, but not the ones that he owned. Is what I'm reading in 22.
I'm not sure what the question is. Any of the homes that the respondent built or in this, I don't want, it's a community, I guess, that they and their spouse are building all of the homes in that community, and she or he is the agent for selling all of those homes. And so they are not letting anyone that was affiliated with this other firm show those homes. So the complaint was against not only the respondent licensee, it was against their firm, and then the new principal broker. And I believe, and the affiliate broker that allegedly tried to extort money from the complainant.
Well, what I'm reading is it says that the respondent also stated that the affiliate was the legal property owner of the listed properties and retained the right to deny entry to the properties. Respondent clarified their firm was not refusing access to any of the complaints agents or complaints for any of the respondent's firm's other listed properties. So I'm just trying to figure out what the difference of the properties.
I'm sorry, I understand. The firm that this respondent is affiliated with, the principal broker of that firm, is saying they are like in their own little bubble. If they don't want to show the homes that they own, that's fine. But we are not keeping anybody else from any of the listings that we have. It's only this one affiliate that is essentially acting on their own with regard to the properties that they own.
And that same affiliate, if I've read all this, interpreted it correctly, stole a plan and they've gone to court over, this builder had a proprietary plan and that's what seems to be the initial fight. And he's saying he didn't want her back in the houses.
Correct. The respondent is the one that is the builder, and they're saying, yes, that they had a proprietary plan, that they have indeed sued before. And that's where they got the $50,000 amount from, because that's what approximately they were awarded in damages when they did that before.
So, and I want to make a distinction. If this was a private citizen, an unlicensed person that said, I don't want to show my homes, okay. I don't agree with it because your object is probably sell. But as an agent owner, I just think there are special obligations placed on licensees when we're showing properties that I just don't feel like it's appropriate to wall off certain properties from other agents because of past litigation or other circumstances. Because again, ultimately the consumers are the ones that are paying, that are aggrieved and are injured, not necessarily the agents.
Kim, but from what Mike asked, this guy, the developer, the owner of the properties, licensee, he says anybody in the world can see it except this one agent can't show my properties. Is that the way you've interpreted it?
Yes, sir.
And I agree with you, Jeff, but if the client really wants to see it, that agent can get somebody else to show it, I guess, or something.
But why should the consumer have to go through that extra hurdle? They've chosen their agent.
That agent stole a plan.
Well, I understand, but it has nothing to do with the consumer.
And to be clear, it was alleged. There was,
Yeah,
I don't,
I don't know who it is. I mean, and to be clear, we don't know.
We
it
don't know.
is.
We don't know who did what, and that's kind of the problem. Like this grudge is affecting the consumer. Like if I'm a consumer, and we don't have our consumer members here today, but I've chosen my agent. I want to go look at that property, and then the agent's like, "Nope, because of who your agent is, you can't go look at the property." So I gotta end my relationship with this agent and get another agent at another firm so I can go see the property. I just think that
Could be at the same firm.
no. In his complaint, he says he won't show it. Any other agents won't show property from that firm.
No.
Go ahead, Ms. Cooper.
you are correct. I'm sorry. I misspoke. It was against the firm as well because the complainant was saying that they were essentially walled off from all of the properties that this person may own. And there's some dispute about that going back and forth, in particular with the current principal broker of that firm.
I just think it adds an extra burden onto the consumer for no reason at all. That is the consumer's fault. I mean, and if we have different recommendations for one or all of these cases, we can choose to dismiss one or accept counsel's recommendation or have different recommendations for each of these cases. If we want to parse it out, but
So Jeff, what you're saying then is if you're a home builder who has a real estate license and you want to sell your homes, then you're obligated to, assuming that a buyer who's your competitor has a agreement to look for a home, you're saying you've got to show that person the home.
I mean, obviously, aside from scheduling conflicts and things like that, actually putting it on a schedule, I think if you are a home builder and you're a licensee and you're building a home to be in the marketplace, then I don't think you can wall off agents that are the other licensees from not being able to show the property just because you don't like them, or you have
Or they're a competitor.
You have you have litigation against them, or you've made allegations against them. I just don't think that is a valid reason to say I'm not going to show you the properties. It's just to me, it's a pettiness to a level that injures the consumer, and I don't think we should allow that to stand.
Where Mike was a minute ago on number 22, the last sentence. Respondent clarified their firm was not refusing access to any of the complainant's agents or complainant for any of the respondent's firm's other listed properties. So I'm confused.
Properties that are not owned by the complainant, or I'm sorry, by the respondent. Any of their listed properties other than those owned by that respondent in 21, the affiliate that started all this, the firm is allowing access to.
Question for the board. So I'm hypothetically, let's say I'm a builder and somebody's just trashing my reputation and has blown multiple deals on my stuff over the last few years. And I decide I just don't want them back in here. So, I mean, they can still come in and, I mean, I don't know. It's a fine line between, how much abuse do I have to take or how much can I, cut off a group of folks that are just detrimental to my business. Because at the end of the day, the seller of any property wants to just sell their property. So unless there's something really going on, they know they're cutting off, a certain percentage of the buyers by not letting other people show the property. So I think it's got to be something deeper. And I don't know. I mean, I don't even know if it's something that sounds so civil to me.
And that was my concern. I feel like I need a chart with all the red yarn getting back to everybody to keep it straight. But what I finally dug down to was I didn't want to cross over into a dispute about this person's property rights. They own these properties. They can do what they want to with them. And if that means not opening it up to a certain affiliate, other licensee, but again, if you want to split the
So-
baby here and just do against the one and not against the other,
Well, and I think if it was just a private property owner, I think I would agree. And my question is, because the owner is a licensee, does that add obligations under the statute where even though they own I mean, you have to disclose when you're an owner agent, owner seller, you have to disclose that up front. Again, so that a consumer coming to you or a client coming to you knows who they're dealing with. So if they're unrepresented, they might decide to go and get representation, and all that kind of stuff. And then you have the personal interest disclosure where, you're selling a property, obviously in your personal interest. To Joe's concerns about, agents coming in and wrecking the property and all that kind of stuff. A lot of times when properties are shown, the agents aren't there. The selling side agents aren't there. Well, maybe you decide to be present so that they, you can monitor their showing and things like that if they have that history. I just think there are a lot of intermediate steps between having a scenario like Commissioner Bagley described or having some kind of grievance against another agent, other than saying, I'm not showing the properties that I own that are clients of this particular agent or this particular firm, and that won't injure the consumer and their ability to look at a property that they may or may not buy. They have a competing right, I would say, to look at a property that they may want to buy. That's what I think. I just think there's so many intermediate steps that they could take besides banning this agent and their clients and their firm. That's what I think, but I'm one vote. So let me do this. Let me call them up individually, starting on case number 21. And this is the allegation against the affiliate, correct? Ms. Cooper? Yes. Okay. Council's recommendation there was to dismiss, and this is the affiliate that is blocking this agent,
this is the owner developer. Yes, sir.
owner developer.
Yes, sir.
So this is the owner developer that is blocking this agent. Council's recommendation was to dismiss. Ms. Cooper's concerns about venturing into property rights notwithstanding. Commissioners, is there a motion on case number 21? And again, for me, I would say honesty and good faith under 6213-4034.
I make a motion to accept council's recommendation.
Second.
I have a motion by Commissioner Gwynn to accept council's recommendation in case number 21, seconded by Commissioner Rampy. Any further discussion? Hearing none. Let's vote. All those in favor of the motion, please say aye.
Aye.
Any opposed? Chairman votes no. So that passes on a 6 aye, 1 no vote. Case number 22, council's recommendation was to dismiss. Is there any other recommendation or motion?
Make a motion to accept council's recommendation.
Second.
I have a motion to accept council's recommendation in case number 22 by Commissioner Gwynn, seconded by Commissioner Rampy. Any further discussion? Hearing none. All those in favor of the motion, please say aye.
Aye.
Any opposed? Chairman votes no. That motion carries on a 6-1 no vote, 1 no vote. Case number 23. Council's recommendation is to dismiss. Is there a motion?
Make a motion. Second. To accept council's recommendation.
I have a motion, case number 23, to accept council's recommendation made by Commissioner Gwynn, seconded by Commissioner Rampy. All those in favor of the motion, please say aye.
Aye.
Any opposed? Chairman votes no. Motion passes on a 6 aye, 1 no. Case number 24. Council's recommendation is to dismiss. Is there a motion?
Make a motion to accept council's recommendation. Second.
Motion on case number 24 by Commissioner Gwynn is to accept council's recommendation, seconded by Commissioner Rampy. All those in favor of the motion, please say aye.
Aye.
Any opposed? Chairman votes no. Motion passes on a 6 aye, 1 no vote. Thank you, Commissioners. Case number 28,
That was me.
Commissioner Smith.
That was me. This was what, if I understand this correctly, there was a complaint made because they felt like the service water line should have been one size, but a different size was installed. But from what I understand, it still met code at the time the 3/4 inch line was installed. And they're wanting either compensation to have that line replaced. And the recommendation was a letter of warning. I'm not sure how many of us know the size of the water line when we sell a house. So I'm going to suggest that I make a motion that we dismiss that unless you have some more information.
Second.
I wanted to clarify that this is the developer builder firm. They are the ones that built the homes. And to clarify that it did not meet codes. It was supposed to be a 1 inch line. They put in a 3/4 inch line. Once this
Okay.
was brought to the county code's attention, all of the homes built by this builder owner, were installed with the correct size
With the
line.
size. Okay.
Yes, ma'am.
I want to withdraw my motion.
Okay.
Are you okay with that, Mr. Second?
Yeah, I'll make a motion.
No, we're withdrawing the motion to
Right.
All right.
to
So-
accept, and
Oh,
now,
sorry.
and now the motion is to do the letter of warning for council's recommendation. So I make a motion that we accept council's recommendation.
Okay, Ms. Commissioner Smith makes a motion to accept council's recommendation in case number 28. Is there a second?
Now you can second.
No.
Seconded by Commissioner Tucker. Any further discussion on the motion?
Yes, this complaint
Commissioner.
against the Realtor that is representing the builder developer that didn't put in the right size water line. And we're holding the Realtor responsible for knowing it should have been a 1 inch line rather than a 3/4 inch line.
That would be to complain it, yes.
Just clarifying.
I'm with you.
Other questions? All right, so the motion on the table is to accept council's recommendation to issue a letter of warning to the respondent. There's no further discussion. Let's vote. All those in favor of the motion, please say aye.
I know I should say aye because I made the motion.
You can vote how you want. You want to say no, you can say no.
Shall I do a roll call vote?
Let's do a roll call vote, Ms. Baker. That's an outstanding suggestion.
Chair Diaz,
I vote no.
Vice Chair Smith.
I'm struggling.
Okay, Chair, Commissioner Begley. No. Commissioner Begley votes no. Commissioner Tucker? No. Commissioner Tucker votes no. Commissioner Gahn? Commissioner Gahn votes no. Commissioner Gwynn?
No.
Commissioner Gwynn votes no. And Commissioner Commissioner Rampy?
No.
And Vice Chair Smith?
No.
Okay, motion fails.
Motion fails on a 7-no vote.
Can I make a
Vote
motion?
is defeated unanimously. Let's put it that way. Is there a motion?
Make a motion to dismiss.
Commissioner Commissioner Gwynn makes a motion to dismiss, seconded by Commissioner Gahn. All those in favor of this motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Case number 40, Commissioner Gahn.
It seems to me that this agent didn't use reasonable care and should be fined for letting somebody access a house without permission.
Civil penalty, sir.
Civil penalty.
Civil penalty.
Yes, sir.
Okay. All right, so reasonable skill and care is 6213-403. I don't know. Is it one? Okay. So you want to assess a civil penalty for violation of 6213-403-1. What's the dollar amount?
500.
Is that a motion?
Yes, sir.
All right, Commissioner Gahn makes the motion to assess a civil penalty in case number 40 of $500 for violation of 6213-403-1. Is there a second?
Second.
Seconded by Commissioner Tucker. Any further discussion? Hearing none, let's vote. All those in favor of the motion, please say aye.
Aye.
Any opposed?
No.
That motion carries on a 6 aye, 1 no vote. Thank you, Commissioners. Case number 45, Commissioner Smith.
Give me just 1 second. This was a discussion on earnest money. And I guess my question was, did you receive a copy of a notification form? Our notification forms also actually will allow us to disperse earnest money without the earnest money form. This is where somebody was trying to buy land to build a house, and they had two, if I'm not mistaken, they had two different people look at it for a building site. And first time they said everything looked good. The second time they said, no, it doesn't look good. The buyers wanted to terminate the contract. So it was a little bit back and forth arguing, and now they want to know where their earnest money is and can we get it back?
Well, I think if I remember this case correctly, the earnest money was sitting with the complainant's agent and not with the
Right.
respondent's agent.
Right.
So the respondent is saying, I don't have your earnest money. Your agent has your earnest money. If you want your earnest money, go get it from them. So is there a way that we can verify where that earnest money is sitting, or?
The respondent is the agent of, is the agent of the other party and says, correct, I don't have it. You
Right.
have to go back to your agent and talk to them about that and the principal broker who's holding the money. I don't have it.
Is there,
But the,
but they're in the purchase and sale agreement or somewhere, it would say who is holding the earnest money,
In the purchase and sale agreement, it's the,
complainant's agent?
correct.
Okay.
so it almost appears they filed the complaint against the wrong person.
I mean,
They filed a complaint against the person they thought was holding the money, but that person is not holding the funds.
correct.
Correct.
Yes, ma'am.
Then I accept council's recommendation to dismiss.
Is that a motion?
Yes, that's the motion.
Commissioner Smith makes a motion to accept council's recommendation in case number 45. Is there a second?
Second.
Seconded by Commissioner Gwynn. Any further discussion? All hearing none, all those in favor of the motion, please say aye.
Aye.
Any opposed? That motion carries unanimously. Now, Commissioner Smith, do you want to administratively open a complaint against the complainant's agent, or
Yes. Yes.
just to find out where
Just
this earnest money is? Or,
Do you want under reasonable skill and care for
Yes.
not following through with their client?
Right.
Okay.
So that's again 6213-4031. Okay. So the motion is to administratively, Commissioner Smith makes a
Yes.
motion to administratively open a complaint against the complainant's agent in case number 45. Is there a second?
It was my motion. Somebody else has to second.
Is there a second? Last call. Hearing none, that motion fails for lack of a second. Moving on. Case number 49. Commissioner
that's-
Smith.
Yes, this is mine. I made a note, how many agents are in this firm? Says that the firm's principal broker license expired in November of 24, and in October, the firm was still holding an active license without an active licensed principal broker. I was just curious how many agents are in that firm right now? And is this civil penalty against the firm? Is that correct? So we have agents out there working for a firm that doesn't realize that their firm doesn't have a active principal broker.
In an effort to be proactive instead of reactive, the team at Trec went through all the firms without an active principal broker, and they received letters. They all received 10-day notices to either get in compliance or a complaint was going to be opened. And this is one of the firms that a complaint was opened because they were not in compliance with having a principal broker with an active real estate license. And in the fall, I think we contacted 43 firms out of 4,300. So 1% of firms didn't have an active principal broker. And so we were proactively looking to make sure everyone was in compliance and that had an active principal broker at their firm. And this happens to be one that was not the case.
And Core shows that that's the only agent or licensee affiliated with that firm.
Okay.
Yes, ma'am.
I make a motion to accept council's recommendation of the $1,000 civil penalty.
Second.
Commissioner Smith. Commissioner Smith makes the motion to accept council's recommendation in case number 49 to assess a $1,000 civil penalty for unlicensed activity, seconded by Commissioner Rampy. Any further discussion? Hearing none, all those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Case number 53, Commissioner Smith. Seems similar to 49.
Well, 3, right?
We are on 53, yes.
Okay. Let me read my notes just a second. You want to give us an update while I'm reading through?
This was another administratively open complaint as a result of audit. Sorry, another administratively open complaint as a result of an audit. The principal broker did confirm that there was an affiliate still associated with the firm that did not have an active license. The affiliate subsequently got an active license. But because they were affiliated with the firm while their license was not active, I recommended the $1,000 civil penalty for unlicensed activity.
This is 53.
Yes, yes, sir. I was just curious on the time frame. The time frame was from June to September that they weren't licensed. Is that correct? No.
This is fair to respond.
No, they're talking about, we're on 53.
Oh, I'm sorry. I did do failure to respond because they did not respond to the complaint. I apologize. They responded to the original audit and said, yes, this person is still with us. A complaint was opened for unlicensed activity. They didn't respond to the complaint. So the recommendation is $1,000 civil penalty for failure to respond.
Failure to respond.
Yes, ma'am.
but not for unlicensed activity.
No, even though that's where my brain went when I was reading the report
Okay.
this morning. Yes, ma'am.
So that was my concern. And also, should that be added on? You got an unlicensed agent out there for a period of time.
It's up to us.
I know. Well, I'm asking you.
Will you make the motion?
Well, they had an active license, but we don't know if they did business or not, but they were on the roster for that firm, correct? But
Yes,
their
ma'am.
license were not active.
From June to at least the end of September. Yes, ma'am.
Okay.
So, and we don't know if that expired license conducted any business.
We do not because they didn't respond to the
They didn't respond.
complaint.
I'm going to accept council's recommendation for the civil penalty for failure to respond. So let's move that one out of the way. So that's my first motion.
All right, Commissioner Smith makes a motion to accept council's recommendation to assess a $1,000 civil penalty for failure to respond. Is there a second? Seconded by Commissioner Bagley. Any further discussion? Hearing none, all those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Case number 53.
Okay.
Is there a part two for you?
Yes. Should a complaint be opened against the principal broker for having someone on the roster without an active license? And I say yes. So I'm going to add another $500 civil penalty,
Is that for failure to supervise?
failure to supervise.
You have to open up a thing against the principal broker, I think.
Right, that's the motion.
Yes.
Do you want to open up a complaint against the
Yes.
principal broker is what you're saying? Not
Yes.
necessarily adding a civil penalty,
Right.
but opening. Okay, very good.
Okay.
Thank you for the clarification.
So the motion is to administratively open a complaint against the principal broker for the respondent in case number 53 for failure to supervise. Is there a second?
Second.
Seconded by Commissioner Rampy. Any further discussion? Hearing none, all those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Case number 55. And I'd like us to consider 55 and 56 together. This is the first case that I've seen where where the recommendation is to close the firm. And is there a specific rule or statute that gives this board the authority to do that?
We received guidance that it would be best for the commission to close the firm instead of administratively closing the firm by Trec team members.
Okay, but is there authority under statute and rule for us to do that?
Yes.
Is it just in the Broker Act or is there a specific
I will defer to council.
statute that we can point to?
It is a rule.
Yeah, we're-
Just a moment. Rule 1260-02-.38 and references the death or extended absence of a principal broker if within 10 days of death, resignation, termination, or incapacity of the broker, we must be notified. At the time of notification, a plan must be submitted which addresses the continuation of operations without a principal broker. If after the 30 days they don't have one, the firm, I'm assuming, must be closed because you can't operate without a principal broker.
Well, 56, you're tying this together, right?
I would like them considered together, yeah.
So 50. So their license,
Look at four.
it says that their principal broker's license expired.
They probably should be uncoupled, 55 and 56.
Okay. Okay, so let's look at 55 then.
I think it's 57. It should have been together.
All right. Well, let's stick with case number 55. So council's recommendation was to close the firm license. And that for lack of a principal broker with a valid license.
It's the same rule under number 4. It's the same rule under number 4 with the assist from Ms. Matlock, that failure to comply with the requirements may result in disciplinary action, including but not limited to a civil penalty or closure of the firm without a principal broker. And because it is considered disciplinary action, it's something that the board must make a motion on, that we can't just do that administratively.
Okay.
Yeah, so this was an amendment that went into effect in September.
Okay. Thank you, staff. So is there a motion for case number 55?
Make a motion, we accept, I make a motion, we accept council's recommendation for number 55.
Commissioner Smith makes a motion that we accept council's recommendation to close the firm license for case number 55, seconded by Commissioner Tucker. Any further discussion? Hearing none, all those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. In case number 56 is the same with the recommendation, but added a civil penalty of $1,000 for unlicensed activity. Is there a motion for case number 56?
I make a motion, we accept council's recommendation for number 56.
Commissioner Smith makes a motion to accept council's recommendation in case number 56. Is there a second?
Second.
Seconded by Commissioner Gwynn. Any further discussion? Hearing none, all those in favor of the motion, please say aye. Any opposed? Hearing none, that motion carries unanimously. Case number 57, Commissioner Smith.
That was similar to 55, where council's recommendation was to close the firm. So I make a motion that we accept council's recommendation on number 57.
Commissioner Smith makes a motion to accept council's recommendation in case number 57 to close the firm. Is there a second? Seconded by Commissioner Gahn. Any further discussion? Hearing none, all those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Case number 59.
I got a quick question.
Go ahead, Commissioner Gwynn.
Is this the first time we've seen a complainant be a commission administrative staff member?
No, sir, that's just how I referred to
Ah,
it.
okay, all right.
All right, so I pulled this case just because I wanted to have something said on the record. I think I recall, this is a couple of years ago now, where the corporate structure in terms of who is required to have a broker or not when they're selling properties, is it an LLC can acquire properties, but they can't sell without having a broker?
And correct,
And then-
because a company cannot, the corporate exemption would require, so we're talking about LLCs, it would require 100% consent from all of the owners to be able to sell
Okay.
property.
So, but other corporate structures may be able to sell depending on the breakdown of the ownership?
This is like related to LLC specifically, however, like it also applies to corporations. I mean, it depends. So what is this case, a corporation?
There's a couple different entities involved, and the complaint was opened, according to their attorney, the complaint was opened against the incorrect respondent, which is why I recommended closure.
Right, so if we're looking at the corporate exemption, which I think is 6213-104A1F. Let's see. Yep. A corporation, foreign or domestic, acting through an officer duly, but this is duly authorized to engage in real estate where a transaction occurs incident to management, lease or sale of other distribution of real estate by the corporation. However, this does not apply to a person who performs the acts in 1024A, which that is the definition for broker, either as a vocation or for compensation, if the compensation is dependent on directly related to the person. So the corporate exemption is supposed to be used for corporations that buy and sell real estate incidental to their positions. So we're talking about like Target and we're talking about Walmart, but it is usually done through an officer, that maybe is like VP of real estate, but that person is salaried and it's not based upon their ability to buy and sell properties. So if it's another entity, it requires that person, whether it's an LLC or a corporation, the amount of persons that are selling the property or own it have to be agreed to sell it. So if there are, you only have ownership interest for the percentage that you are responsible for. So if it's a multi-member LLC, you can sell, if I own 20%, I can sell 20% of property, cannot sell 100% of property.
Okay.
Yes.
If you're the managing member of the LLC,
Doesn't matter.
Be careful what you say now, Mr. Chair.
If you're the managing and only member of the LLC, then you can sell the entire property. But your ownership interest only goes to as much as you own in the LLC or LLP, corporation, et cetera, et cetera.
All right, so when we originally heard this case, council's recommendation was $1,000 civil penalty for unlicensed activity and a $250 penalty for violating rules 1260-02-.123B for a total civil penalty of $7,500. That's not right. $1,000 and $250. Why does it say 7,500?
Because there's more than one violation.
More than one violation. Okay.
For each violation.
All right, so we accepted council's recommendation then, and with new information, their recommendation has changed to dismiss and open a complaint against Company A for possible unlicensed activity. Is there a motion, commissioners?
I make the motion to accept council's recommendation.
Second.
I have a motion by Commissioner Smith to accept council's recommendation in case number 59, seconded by Commissioner Gwynn. Any further conversation or discussion? Hearing none, all those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Case number 66, Commissioner Smith.
Second. Okay, on that one. I didn't understand this sentence. Second paragraph. However, the complainant didn't request a copy of the denial letter, and the agent couldn't fail to respond in a timely manner if there was no request. But I don't know what that means.
So essentially that's what the.
Oh, I'm sorry.
It's me, yeah, me from now on.
Okay.
So essentially what was happening in that one is that in the response, this was the principal broker responding. And they were saying that since the complainant didn't request anything, they can't possibly fail to give the information if they weren't requested to begin with. It's probably just like weirdly worded, but like that's how they phrased it. So I try to like incorporate as much as their language as possible, but I can reword that if it's confusing.
Okay, is that a true statement? If I have a complaint filed against me and I want to send proof, do I just say I'm not sending it because you didn't ask me?
Well, in the complaint, they were saying that there was a denial letter that they didn't provide automatically to them, like the agent. So this is like the principal broker wasn't part of it, but their agent was. And so they're saying the agent didn't give a denial letter automatically when they were aware of it. And so the principal broker is pretty much saying like, if you didn't ask for the denial letter, how can we possibly be in violation? That's their assertion.
I think the complainant has some issues themselves in this, that they didn't use skill and care as well in following up and making sure they had everything that they need to have.
Council's recommendation was to issue a letter of warning to the respondent. and they also recommend to administratively open against the agent involved in the transaction. Which agent would that be? Would that be the agent for the complainant or the respondent?
Agent for the respondent is the respondent's agent.
Okay. What do you think, Commissioner Smith?
I make a motion to accept council's recommendation.
Commissioner Smith makes a motion to accept council's recommendation in case number 66 to send a letter of warning to the broker and administratively open a complaint against the agent. Any further, is there a second? Seconded by Commissioner Tucker. Any further discussion? Hearing none, let's vote. All those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Case number 71, that's both of us. I'll go. All
I think we
right,
both pulled out.
we did. So it seems to me that there was an original civil penalty of $13,000. I guess there's 13 separate incidents.
There were 13 different unlicensed individuals
Unlicensed
that were
agents, right?
registered to that one, but that was against the firm. This one's against the principal broker.
Okay, so
Yes.
I saw this. I thought maybe there was a reduction. So the 13 other violations are going to remain against the firm?
Yes, the consent order's already been sent out for that.
Okay,
That's
so,
what we'll
so
likely
this
be
new
a-
one is just against the firm,
This one's against the principal
against the
broker.
principal broker.
Yes, but it's the same affiliates that are unlicensed. They're still associated with the firm. They did not remove them
Okay.
even after receiving the consent order.
So that was my question was, is this civil penalty in addition to what we already had agreed upon? And your answer was yes.
Yes, that
Okay.
it would like be a lot to
So is
ask for
this-
an additional 13,000.
Yes.
Although I think be justified, but just seemed like a lot when we're trying to resolve the case instead of.
Sure. Sure.
So, and then you're assessing two civil penalties, $1,000 each for two different violations against the principal broker?
Yes,
Has the 13,000 been paid?
no,
When was it due?
They haven't agreed to it yet?
they have not. It's likely gonna be a hearing, but because this one was also on and related, I kind of want to see
Okay.
what the commission wanted to do with that for going forward with a hearing. So I'm just doing it 2 times
So it'll be 15,000 now?
total, yes.
Is there a motion?
I make a motion that we accept council's recommendation.
Commissioner Smith makes a motion to accept council's recommendation in case number 71. Is there a second? Second. Seconded by Commissioner Bagley. Any further discussion? Hearing none, all those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Case number 135, I think is next. Yes. Gonna get carpal tunnel up here doing all these pages. So my question on this one is that you refer back to a complaint that was presented at an earlier legal report. And I wanted to see if the civil penalties matched on the two cases. Do you know that?
I believe so, but I can check just to make sure.
Okay. Steve? Yes. You're fine. Sorry. Probably need to unplug the routers and such so you don't get the wheel.
I'm an expert.
Yeah, that's right.
Yeah, just another moment, please, while we pull up this complaint number. It's the second number.
She had CE. Okay. It's not done yet. Okay. Yeah, it is. Sorry. Oh, no, no problem. Okay, we finally found it. All good. So it was $1,000, and then they were also continuing education. Sorry, that was for the related case that was previously presented. And they paid that. The affiliate did.
Okay, so my original question was make sure that the civil penalties between these two matched, and you said we added education to the earlier complaint,
Yes.
to the affiliate? Okay.
And this one's their principal broker. And it was just failure to
And,
supervise.
and.
Oh, sorry. I'm applying an unlicensed individual.
Right.
Sorry.
So council's recommendation is $1,000 civil penalty for employing an unlicensed individual. Is there a motion? Commissioner Smith makes a motion to accept council's recommendation in case number 135. Is there a second? Seconded by Commissioner Tucker. Any further discussion? Hearing none, all those in favor of the motion, please say aye. Any opposed? Hearing none, that motion carries unanimously. Case number 136, Commissioner Smith.
That's me. My question was, this person was advertising themselves as a real estate agent before their license were active. And I understand that the recommendation is to dismiss, but I'm wondering about, should we open up a complaint against the broker? The broker should be aware of who's advertising, who's licensed, whose license is on their wall.
I don't know if I saw any, like, of the actual advertisement they were alleging in complaint.
Okay.
So based off my understanding, it was that they had passed, but there's like maybe like a 2-3 day
Okay.
window where they were like, I'm a licensed agent,
Okay.
but they hadn't gotten the official documentation from us saying, congratulations.
But they could have looked it up and saw that they were on the website before they actually got the license. Is
I think
that
that's what,
correct?
I think that's what happened. I think they were aware that
Okay.
they passed and then they just were telling people that they were licensed, but I didn't
Okay.
see like anything like on Facebook or social media or
Okay.
things like that saying like, here I am before they actually
Okay.
received anything.
All right, you're good. I make a motion to accept council's recommendation to dismiss on 136.
Commissioner Smith makes the motion. Commissioner Bagley makes a second to accept council's recommendation and dismiss case number 136. Any further discussion? Hearing none, all those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Case number 139.
That's me again.
Yeah,
Am I the only one on that one?
you are.
This one is where it says we did not receive a response.
Yes.
Is that correct?
Yes, we did not receive a response from,
And
This
this
one.
was on a timeshare,
Yes.
correct?
Mm.
So why would we not give a civil penalty for not responding?
we can. The reason I said dismiss was because the underlying allegations, they weren't gonna be able, it was outside the time limit anyway, by like 2 years, so they weren't gonna be able to rescind it anyway. But we can definitely
But they
assess
should have
something.
responded regardless.
They should have responded, yes.
Okay, I make a recommendation that we assess a civil penalty of $1,000 for failure to respond.
Commissioner Smith makes a motion to assess a civil penalty to the respondent for failure to respond in case number 141. Is there a second?
No.
I'm sorry,
139.
139. Case number 139. Is there a second?
Second.
Seconded by Commissioner Rampy. Any further discussion? Hearing none, all those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Now it's case number 141, and that's me. So on occasion, sometimes you make a recommendation to dismiss because you don't think there's enough evidence to proceed to hearing.
Yes. Mhm.
And is that the circumstances here?
So in 141, I actually spoke with the respondent, who's the principal broker, and the reason the new recommendation was for dismissal was because of the circumstances around it. So it was essentially an affiliate who kind of refused to listen, and they weren't aware of like a social media post that was being made that was in violation. They essentially used like the wrong last name in their new advertising. And once they were aware, they like immediately asked them to take it down. They made them go through additional education. I think they tried to work with them additionally for for multiple months on top of that, just to make sure compliance was maintained. And unfortunately, they had to be let go just because of like consistent issues. So that's essentially why the new recommendation was for dismissal, only because I felt like they took extra steps to make sure this happened and they corrected anything, and they just were unaware of it. Only because during the time of the posting, they were in a completely different like education course. And so that's probably why it was like a little delay, like a couple hours before it could even be taken down.
So originally, your recommendation was to assess a penalty of $750 for an advertising violation. We accepted that recommendation. So after this new information, your recommendation is to dismiss.
Yes.
Is there a motion for case number 141?
I make a motion to accept council's recommendation for number 141.
Second.
Commissioner Smith makes a motion to accept council's new recommendation in case number 141, seconded by Commissioner Rampy. Any further discussion? Hearing none, all those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Thank you very much, Commissioners. That concludes the legal report.
I want to make a motion to reconsider on number 9.
Number 9.
Commissioner Bagley makes a motion to reconsider on case number 8.
It's going to take us forever.
Number
to get back
8.
here.
Is
Number-
it 8 or 9?
Let me, hold on a second. It's 9, I think.
Case number 9.
You may have a trick how to get back here quicker.
I think there's
You can close it and reopen it.
I tried that.
go. See this down here?
Okay.
They went too far.
It's the third page from the left, that sheet over there.
It's page 6 of the PDF.
What
Yeah.
is it?
Yeah, I was going
Oh.
to do the same
If
thing.
everybody else can go to number 9. I'd just like to add, so I'm gonna make a motion to add education.
Well, hold on. We got to get a motion to reconsider case number 9. All right, Commissioner Bagley makes a motion to reconsider case number 9. Is there a second?
Second,
Seconded by Commissioner Tucker. Any further discussion? Hearing none. All those in favor of the motion to reconsider, say aye.
Aye.
Any opposed? All right, hearing none. Case number 9 is on the docket. Commissioner Bagley.
I'd like to add some education to this recommendation. Obviously, they're not getting the message about advertising. So maybe an ethics class and then what else could fit into advertising? What else would be?
Well, ethics is through we can do core.
Ms. Brittany, does the trace course have an advertising
The
element to it?
trace course does, that is 30 hours. It does cover that. There is a whole section that covers essentially more in depth of what you would cover in the core course for the 6 hours. So it just depends on how you're feeling.
Okay, I'm going to make a recommendation that on number 9, that we add the affiliate has to take the trace course within
It's usually
6 months,
180 days.
180 days.
Yes, sir.
Not count towards continuing education.
And it does not count toward continuing education.
All right, Commissioner Bagley makes a motion to add an education requirement to case number 9 to require the respondent to complete the trace course in 180 days, and the course does not count towards their continuing education. Is there a second?
second,
Seconded by Commissioner Tucker. Any further discussion? All those in favor of the motion, please say aye. Any opposed? Hearing none, the motion carries unanimously. Commissioners want to reconsider any other cases? Hearing none, I will conclude the legal report. We are on to new business. Is there any new business for the commission?
The next meeting of the Tennessee Real Estate Commission will be at East Tennessee Realtors in Knoxville at 609 North Wesson Garber Road. I'm sorry if I mispronounced that, in Knoxville.
You say that one more time?
I had difficulty the first time. It is written on your agendas and I'll send out an email. And lodging information will be communicated to you within the next week or so. Is there anyone that will not need lodging for Knoxville? I think we don't have any commissioners based in Knoxville. Is that correct?
You said the meeting's the 9th or the 8th?
The April 8th, 2026. I would also like to mention that Trec will be offering 4 hours of free CE on April 7th. We'll be offering the State Fire Marshal Office course, which Commissioner Smith has attended. We will also be offering a Rice course that is led by an instructor with Rice Insurance. Lastly, Brittany, Anna, and I will also be offering 1 hour of CE, giving updates on April 7th in Knoxville at the East Tennessee Realtors at the address listed on the agenda. Correct. It's on the 7th. And I believe the courses begin at 9. Yes. 9 Eastern.
It'll begin when you get there.
No, sir, not exactly. Not exactly.
email letting us know.
Yes, we'll communicate that in addition to lodging information at that time. That concludes new business for our end.
It is putting her on blast. Yeah. Got it. All right, commissioners, any other business? Staff? Hearing none, we stand adjourned until the April meeting.
Thank you.